My name is Marina Pavlovich. I'm an associate professor here at the University of Ottawa, and I think we're going to have the battle of the OGs. Who is the original OG? And I think Alana and Greg are. I do predate Alex and Jason, and so I started my LLM here in 2002, and I actually never left. Unlike all of these people who went to do amazing things, I just never left because it's the best place to stay and play and grow and have friends. So it is. And it has been a very nostalgic day. I think I've given more hugs today than I have given in my entire life, collectively. And it's really amazing to have everybody back. It is a different kind of reunion where, for us who has stayed here, it's like just amazing to see how people have gone off and done amazing things with just like a little, we just like gave you whatever, a little platform, and you've gone and done amazing things. So we're gonna wrap up the day with the panel of our distinguished alum who are working in various industries. And it really brings back together the sort of 5 stakeholders that we looked at throughout the day. And so we're going to hear their perspectives on working in different industries at different geographical locations too, and how they experience law and tech and what brought him to law and tech and what they see are issues for the next 25 years and plus. And as somebody said, we're probably, none of us are probably going to be here for the next 25 years, which was kind of depressing. So I guess we have we're not going to be here for the next, anniversary. So the people who we have on the panel, we have Milana McCullough, who is the president and head of legal from Reddit. Jason Young, who you all met and never ever trust him with your oral arguments, who is Associate General Counsel for Americas for PayPal. Cynthiana Guthieu, who is the Director of Data Strategy and Partner Services at TELUS. Abigail Smith, Director of Corporate Counsel for Regeneron. Colin Lachance, Principal for PGAY Consulting. And Andy Kaplan-Mirth, Vice President, Regulatory and Career Affairs at TechSavvy. Colin, I'm going to turn it to you. Take it away. Thank you.
All right. Thank you, Marina, and thanks, everybody, for spending your afternoon with us. I'm really looking forward to this. As you heard from the brief introductions, we're covering some incredible organizations, some incredible industries right there with tech. The other thing that probably don't need to point out is we have an in-house perspective. And I actually want to spend a little time talking about why that's interesting and important. Because most of us, when we enter law school, we know about being a lawyer in private practice. We probably know about being judges. We probably think about a wide range of areas where lawyers operate, but we rarely, until we get into our professional careers, think about the role of in-house counsel. So it's a way that people become accidental technology lawyers. In my own case, I articled at a 20-lawyer firm in Edmonton a long time ago, finished a child welfare trial on a Thursday, and started defending TELUS in front of the CRTC the following Monday. So, and then for many, many years thereafter, my sense of the law was influenced by the lens of working for a large phone company until I got here. But we'll get to that story in a minute. We're going to take an opportunity here to meet our panelists who are going to talk a little bit about how they thought about technology issues when they began their legal education journey, what were the things that they were focused on, and what their focus is now. And through that, you're going to hear a little bit about their motivation and their journey and what they see as priorities. Milana, I'm going to start with you.
Hi, everyone. So we're the fun panel, I guess, at the end, and just before drinks, too. So we'll make it interesting and maybe even a little spicy. All right. So my current role now is leading the legal team at Reddit. And when he said like accidental technology lawyer, that was totally not me, because I was very obsessed with being a technology lawyer right from the start. Way back, so I graduated in 2004, which is a very, very long time ago now. And I was part of the first CIPIC class, I think. I was like in that first group of people who did that, and was the first intern from here that went to EPIC, the Electronic Privacy Information Center, down in DC. And I was completely obsessed with Google already back then, so much so that I would stalk David Drummond when I was in DC, who was the then general counsel there, and actually ended up meeting my husband at an event where I was trying to stalk David Drummond. So that's how obsessed I was with it. Anyways, I was always wanted to figure out how to get from here to there, and there being Silicon Valley. And I ended up at Google for a very, almost 14 years, and was part of their first product council team over there. And there, the areas I focused on, I was thinking about it, was actually very similar to what I'm doing now, which is navigating global content regulation, Section 230, intermediary liability, copyright. I mean, at that point, it might have been in a different form, like what size image could Google display on its search engine, but which is not that different than some of the issues that we're dealing with now. It's a new form of copyright. It's about AI training, but it's still copyright issues in new forms. And it was really a lot about fitting old laws into the internet age. And a lot of what we were doing back then was just trying to figure these things out, right? Like, what does a disclosure look like? What does consent look like? How can we use that third-party content on our platform, right? And when I, take a step back and I think about all the things that we're doing now at Reddit and the issues, that keep me up at night and that we're thinking about now, it's also all the same. It's new global content regulations. It's, new forms of IP, and how to navigate the gray. And it's actually very similar in terms of issues, although now obviously thinking about things like scaling that and a lot of, and also just navigating just complexities with laws that are always changing. But yeah, it was, I think, fairly similar, but to back then. So I'll hand it over to the next person.
Hello. Thank you. I think I'm going to start by talking about what I did at the center when I started, and then just quickly my path to where I am now. So the year was 2009. It was a time of acronyms: PBD, DRM, and digital locks, FB, Facebook, IoT, Internet of Things. And we did a lot of work on what at the time, as Kristen, who's also part of the six-pack, the super six-pack, she talked about there's futuristic ideas. We talked a lot about robotics, predictive technologies, and privacy and impact on human rights. And one of the technologies that we looked at more closely through our time with working with Ian Kerr was robotics. And we got to go to this really cool robot lab, got to meet Milena at Google. And it really was a time of looking at these technologies, thinking into the future and asking, what are the ethical values within robot design? And you've heard about this conference, We Robot, where a couple of us came and spoke. I specifically presented on human-robot interactions and the impact on consent between people and social robots. And I remember there was a conversation there about whether robots are just another type of toaster. Is it the technology itself that results in harms or whatever, or is it the way people use it? And I think we've come a long way since then. I think we know that there are ethical principles embedded in the technology and what the technology is intended to do. And I remember this robot called Jibo. I don't know if you guys have heard of Jibo. It's a company that's since closed down. It's this like circle-shaped robot with a face. It's just a little dot. And there was a commercial where it would tell stories to kids. So the parents would set it up and tell stories to its kids. And I remember talking to Ian Kerr about it, and I was like, there's something, I didn't have kids at the time, I do now. There's something weird about this. And he was like, yeah. And, he had his daughter. He said, I love reading stories to my kids. Sure, it saves me time, but this is an interaction with your kid that is really, really important. And it's not something that should be delegated to a robot or to technology. So that was my background. Those were my interests at the time. And then, of course, I had to get a job. And so I applied to law firms, as you do. And I would say, I'm really into tech law. And they would say, IP law, right? Like intellectual property, copyright, trademarks, patents. And I would go, yes, that is tech law, but no, that's not where I'm coming from. So I had an interest in privacy, and I've had a bit of a bouncing kind of career where I've gotten to see privacy from the perspective of private practice. I worked at FMC, which then became Dentons, and the center's always kind of tethered through my experience. That's, from there I worked at the BC Privacy Commissioner's office, where I met Online Twists and many brilliant people. And from there I worked at a law firm where I did cyber breach advice and class action, privacy class action lawsuits, where I met Alex Cameron, different firms, but similar type of work. And then I ended up at TELUS. So it's been I've gotten to see tech law, I've gotten to see privacy from different angles, private practice, regulator, in-house. And it's really shaped the way I look at issues and the way that I guide and operationalize and implement what the business has to do to be compliant and to, kind of do what's right overall. So I'll stop there. I think I've been talking for a while. Over to you.
Is that on? Yeah? Okay. Hi, Jason Young. It's wonderful. I just want to say first, it's wonderful to be here, to see all of you, to think about the history and the impact that this program has had on tech law policy in Canada and on each of us in our own way. As Milana mentioned, I guess we're having some disagreement about this, I think, but I was, I guess, one of the OG members of the CLTS. I can say that I was on Jeremy's interview panel, so I predated Jeremy.
Is this a battle?
By the way, I was totally unqualified. I was totally unqualified to judge Jeremy for anything, but somebody decided it was a good idea to have a student representative, so I was one of them. I worked for Ian. Ian was my thesis supervisor, and I remember him when he had hair. So I'll just start at the beginning, maybe. I actually started my career after undergrad at the Office of the Information and Privacy Commissioner for BC under David Flaherty, who was the first commissioner. And I worked there for 3 years and learned a lot about how to operate in the corporate world, how to think about issues. It was a bit like going to law school before law school. And then when David retired, I went off to law school. I went to Queen's and had a number of experiences there. Went to Epic. I went to Epic before you. Yeah, I did. I went to Epic before you. I went to Epic before I came here. Anyway, we can argue about it later. I knew her husband before she did.
Oh my God, this is going to get spicy.
I worked, Steph Perrin, who is here somewhere, hired me at Zero Knowledge Systems, which is a Montreal-based company, technology company, that was trying to sell privacy technology to the masses. Their initial business case was consumer privacy. And they had to pivot at some point because they realized, or we realized, that consumers cared about privacy, but if you gave them a Big Mac, they were willing to give up their information, right? And so I think actually that might still be true, that we say that we care about privacy, but a lot of us still are willing to give up our personal information, our privacy rights for the convenience of various services. And then I came here. I met Ian at a conference, and he said to me quite serendipitously, "You should come and study at this new program that we have." And I did. Michael Geist was here, and I admired his work very much, and came up here and had an amazing time. And my career since then has been much like Milana's. I intended to be a tech lawyer, or at least aspired to be a tech lawyer, and that's what I've done. I was in private practice. Half of my practice initially was IP litigation, as you mentioned, and then the other half was tech advisory work. But I really loved the tech advisory work, and I wanted to do more of that. I left to a client, Yahoo, and Yahoo was in Canada at that time prior to Google being here. So they were the 500-pound gorilla in the ad tech space, and at least in Canada. And it was a pretty interesting time. But it was also frustrating for me, and ultimately why I left Yahoo, because although the whole business was about collecting personal information and trading off of that, there were really no rules that practically applied. You might say privacy, PIPEDA was around at that time, but the way that this information was being collected by DoubleClick and the other networks and by Yahoo, the laws just weren't, they weren't, it was difficult to apply them in a way that protected people's privacy. And so, I learned a lot there, but I found it personally frustrating that as a lawyer, as somebody who cared about privacy, I didn't have a lot of impact. And so I ended up in financial services. I ended up at TD, and now I'm at PayPal. I'll fast forward. And PayPal is kind of the intersection of my financial services experience and my tech experience, and it's been a wild ride. We've been doing the PayPal platform, I think, because we're a global company, has given me the opportunity to see how tech policy is developed in different jurisdictions around the world. And Canada tends to be, I won't even say a fast follower, they're a slow follower on a lot of different legal issues relating to technology. And so you can look to other jurisdictions, Australia, the UK, even Brazil, for examples of how different jurisdictions are dealing with technology issues and how effective that might be. And part of my job at PayPal has been to position PayPal as an, and I'm here speaking for myself, not PayPal, but to position PayPal as an honest broker in the tech policy conversations that are occurring where we might have an interest. And what I mean by that is, as I think somebody said on the regulatory panel, regulators and policymakers don't have the resources or the sophistication to understand and work through the issues that global platforms represent, right? The technology is simply too complicated. And there are many people at those platforms that don't understand the technology. And so part of my role in Canada and in other markets has been to help government, help regulators both understand our business, but understand how the technology works, how the payments ecosystem works, and thereby, obviously address or advocate for our interests. But the way that I've approached it is to do that, I would like to say, in a more altruistic way. What is best for the ecosystem, and how does that align with our interests? And often, I've found that they do. And so I'll stop there.
Hi. So I came to technology law by way of the Harvard Mouse case, which was a fabulous case from, 15 years ago or so, that related to the patentability of an oncomouse, of a genetically modified mouse that was predisposed to develop cancer and which had tremendous applications in cancer research. At the time, I was a biochemistry student and my day-to-day was genetic research. So I was really interested to see this opportunity in law because I was simultaneously discovering that I was more of a library person than a lab person. And so the opportunity to think about the intersection of economic policy and scientific innovation and law was really exciting. And I got to spend time thinking about those things and developing those skills at Ottawa. And today I'm a life sciences generalist, which is not a job that I knew existed before law school or really until some years after law school. But it gives me this fabulous opportunity to engage cross-functionally with life sciences issues in Canadian law.
Well, I'm Andy Kaplan-Worth, and if we're competing about who's OG, I don't know for sure, but I started here in 2002, I think, for law school. And I'm old enough that I have an LLB. I hear everybody talking about JDs now. So when I started, I think it was really just sort of .com, internet, heady days. And I kind of had like a casual nerdy technology background, but I didn't have a formal technology background and I was in graduate school at the time, actually doing cognitive science. And if I'd stayed in it, I would be doing AI now. But I didn't want to pursue a PhD, and law school honestly seemed like a good backup plan. It was a way to be involved in the technology and in the policy with kind of a career path. That's how it felt. We had a young kid at the time, and it really was kind of a plan B, and it worked out better than I could have expected. It was like a great plan B. So when I came here, I thought that I would be working on internet law. What I started working on, I was a research assistant for Professor Geist, and he put me to work summarizing international spam regulation because the U.S. had the CAN-SPAM Act, and Canada was, I think, maybe starting to think about maybe regulating it. And I did an internship at Industrie Canada in a group that was working on spam legislation. And what I couldn't have known then was that about 5 or 6 years later, I would then work back in that same group at Industrie Canada on the policy side, developing the legislation that became CASL, Canada's anti-spam law. So a real cool, what did I start working in, and where did that take me? I worked in Industrie Canada for a while, and now I work at Tech Savvy. I've been here for 10 years, working on the regulatory and carrier affairs, which means our company buys services from large companies. We have often very difficult relationships with them because we're always fighting with them. And carrier affairs was a position that we created to basically be develop a better relationship with these companies that that are so important to us. One other sort of interesting parallel was that one of the things that we started working at, a few people have mentioned the file sharing, copyright infringement disputes that were going on at the time. I was in that courtroom also when Alex was arguing, because I was part of a small student group that had created a legal information website because so many people were sending in messages to CIPIC asking questions about, what does this infringement lawsuit mean for me? We created this informational kind of website, and then we were tracking the progress of that litigation. So kind of peripherally, as a student involved in that. And now at Tech Savvy, I'm on this sort of the internet service provider side of both dealing with the copyright notice and notice regime, which has been around for a long time, but there's this sort of the regular implementation of it and compliance issues. And also parts of it are badly drafted and have led to some serious problems for liability, have created liability where I think it wasn't expected. So I continue to be involved in that, both lobbying on that and also and also compliance work. And now that has evolved into site blocking, very much an extension of some of the same issues. We always talked about network neutrality, and it is a very real issue at an ISP that is the subject of site blocking orders that we fought for a while, and now we kind of just implement their routine in Canada, for better or worse.
Awesome. Thanks, everybody. And so in addition to the personal stories you've heard, you've also heard about 25 years of really interesting technology issues that have been debated, thought through in Canada, and how they're linked to some of these larger issues. I'm just going to give you a quick personal anecdote of mine. So I came to the University of Ottawa later as a second degree. So if y'all are Degrassi, I'm Degrassi next generation. Alana Morshat was one of my first instructors, as was Michael Geist. That was in 2010, 15 years ago, fall of 2010 I started. And I chose the University of Ottawa because I was working in policy, because I was working for a phone company that was dealing with a lot of these same issues that have been discussed, the internet policy, the file sharing, all sorts of these things. So when I said, well, I want to get deeper into it, I want to understand it more, I came here. This was the right place to do it. What I didn't expect is that my career would change dramatically within about 8 months of showing up. Actually, not even 8 months. I started with an intent of digging deeper into policies around government rulemaking, both at an advanced, sort of a preliminary level, as well as a post hoc through like cabinet appeals and so on. That's what I wanted to study. 6 months later, I was the CEO of Canley. I was a government relations person, then I was that. And then my career went from being about laws applicable to technology to technology's application to law. And it changed what were my priorities. And so what we heard is people were going through, their priorities evolved. In some cases, they stayed the same. I want to start actually at Andy at the end and ask Andy, there's a number of things that you're looking at right now. Like pick 2 of your top 5 technology things that really occupy your time right now. And tell us a little bit about them.
I mean, the top priority has to be like the main thing that I work on is just the lifeblood of our company, which is wholesale competitive internet services. So, if you don't know, TechSavvy is the largest competitive internet and phone and now TV also service provider. And we use this framework, this regulatory framework that was created in order to allow a range of competitive services to run over telecommunications facilities that kind of have a tendency to be monopoly facilities. So, if it weren't for some kind of service-based framework, you would really only have the choice of a phone company and a cable company, essentially. We're so reliant on the regulatory framework and regulations in general that a lot of our work is participating in CRTC proceedings to address challenges, to keep this framework alive, to set rates. And I've been at TechSavvy for 10 and a half years, and we have been basically involved in a prolonged battle over those things for that whole time. A lot of the industry has collapsed around us. TechSavvy's kind of the last company standing. There are some others, but we're by far the largest now because all of the others have sold themselves to incumbents. So, day to day, that is my main thing. So, I mean, inherently, it's a technology issue. It's very much just about an ISP. It does involve drawing on understanding technology to some degree. So, I'm not going to go deep into the weeds about aggregated and disaggregated, which is kind of the subject matter of this, but the way that we connect to large carriers backhaul their traffic, all the different components of the network that we need to either build or provision are all important to this. And the company understands it very well. It's a tiny company. It's run by, technology people who all understand this. And then they bring in these lawyers from outside. They made a very deliberate choice to bring in lawyers who I think understand this technology or would be able to learn and understand this technology. And so, yeah, like day to day advocating for the company before the CRTC and sort of publicly also, that's been very important. One other thing that I want to say, because privacy is actually a really important part of my work as well, and sort of customer, like consumer advocacy, but from inside the company, has been very important. And so one example of this, I feel like this has sort of carried my privacy, sort of civil society kind of heritage, I guess, from this program into industry, has been that we created this policy for how we deal with law enforcement. You're at an ISP, law enforcement come to us, they want to know who was using this IP address at a certain time. And a lot of ISPs sort of I guess if you're a small ISP, you might just hand stuff over because you don't understand how the law works. You might fight about it a lot. We decided very early on to create a very clear set of policies so we could say to police, as long as you do these things, we will cooperate. Come back with an order. This is the thing. And then we took that policy and we ended up publishing it so that our customers could see it as well. So we have a law enforcement guide, I think is what it's called, that sets out all of those policies, and it kind of balances both the legal obligations and also the customer, sort of the transparency, and it helped us really navigate the privacy frameworks and do it in a way that would stand up to scrutiny. So, a couple of examples.
Okay, so in terms of high-level priorities, from a health tech perspective, you're always talking about access to treatment, and in Canada, systems sustainability, because you've probably read 1,000 articles about how our health system is crumbling. And I think it's probably a bit more nuanced than that. There are parts of it that work well and parts of it that work not so well. But one thing that the industry is constantly talking about is how the various players in the healthcare ecosystem work together to facilitate those goals.
Again, from the perspective of the broader legal issues that you engage with, what?
So, for example, it's novel funding agreements with provinces. It's working on new types of clinical arrangements that will permit for less centralized healthcare in the communities that need it. Those kinds of projects.
Yeah, when I was thinking of this question, I went back to when I started here and some of the big questions of the day at that time. And I was reminded of an article that an esteemed U.S. jurist, Justice Easterbrook, wrote called The Law of the Horse. And he was arguing in that paper that we didn't need a separate law for cyberspace, for the internet, that existing laws of general application would adapt or were appropriate for cyberspace, for behavior that was taking place there. Around the same time, Michael wrote an article, a very well-known article called "Is There a There There?" I always like that title. And Michael was asking he was saying, is cyberspace sufficiently different that perhaps we need to think about a new legal framework? And is it in fact a separate jurisdiction altogether? And when I think about what I spend a lot of my time doing now, it's trying to fit a complex global operation into national laws. How does a complex global organization, one that seeks to that operates sort of in a way that no national approach could take into account. How do we do that in a way that mitigates our risk, mitigates our exposure, and is efficient? And so it's tied to that, I think, that question. We've seen over the years that the national approach, and it was alluded to again on the regulatory panel, that the national approach to issues that arise out of technology, particularly big tech, are difficult to do at the national level, right? The regulators don't have the resources. Issues, technology like AI or other matters aren't necessarily things that can be addressed from a national perspective. And so I spend a lot of my time thinking about that. And I spend a lot of time trying to explain how our technology works to various regulators around the world in order to, again, as I said before, help them understand how to regulate efficiently, how to address the risks that they care about. It's not about avoiding the risks. It's about working together to try and craft a solution that works for both. So I think that's what I spend a lot of time thinking and doing.
Easy.
You asked about priorities, but can I focus more on kind of what's just top of mind? It's slightly different than priorities because there's a lot of priorities. And there's a lot of things that are top of mind, but I'm just going to pick two. And the two I'm going to talk about is first, the evolution of the privacy professional within the business. I think there's been a lot of change even within the last 5 years. And the second thing I want to talk about is data governance and data literacy. That's something that surprised me, I think, as my career progressed, because it is not something I thought about when I was in law school. I didn't really think about data quality issues, and it seemed kind of boring at the time. And when you're within an organization, it is such an important aspect of handling data. So I'll talk about the first one, which is the privacy professional. Being what used to be called the privacy professional, which I would argue now is more like a data professional, whether you're a lawyer or you've just kind of built up that expertise, can be incredibly demanding nowadays. We have requirements where not legal, but kind of business requirements where you need to know the technology. You really need to understand, how does that LLM work? How does that product actually work? Which was kind of always the case. There's more complexity there. But then on top of that, if you're in an organization that operates globally or across multiple jurisdictions, now you're also required to familiarize yourself with data protection laws, with different standards, which is also quite challenging and demanding. Lots of work there for private practice lawyers. And then on top of that, if you're dealing in areas that are novel, like dealing with technology that is novel, like AI, where there isn't law really in place yet, you are looking at standards and best practices that you also have to know about. And then how do you take all that and help the business operationalize, actually implement, actually do what you're asking them to do, what the external lawyers advise, what the government requires you to do, and what the academics provide frameworks and lenses for. So it is very, very challenging, because now you're not just talking about privacy with all these requirements. AI, I mentioned, not a lot of laws, some laws, but as time passes, and then data governance. So it's very demanding, very complex, and for smaller organizations that don't have the resources, I think it's very challenging. I'm not saying that they shouldn't be doing this. This is what needs to happen. It's just challenging. And so the role has changed, has evolved. And so the other thing I want to talk about is data governance and specifically data literacy. I think that's something that needs to happen at a cultural level within organizations, and it's very, very important, because deploying any kind of AI or applying AI requires your data to be thought through and properly stored and all the data governance principles about retention, all of those things that happens with the data throughout its life cycle are really important to understand. The people within the organization who handle the data, who interpret the data, who read it, who use it, have to have a certain base level of data literacy. So that's another thing that I think is top of mind when you're working within an organization.
All right. So in terms of priorities or things that are top of mind or keep me up at night, there's really two. One is more tactical, and then one is of substance. So I'll start with the tactical one, which is really for a company like Reddit, which I would call a old new company, in that we've existed for a very, very long time, since 2006, and but only recently have become much more in the public eye and become much more popular. It's really about scale, right? And I think most of what I do right now, is figuring out how to handle a huge increase in volume and litigation all over the world, regulatory scrutiny everywhere, and helping set up new entities and sort of market entry into new jurisdictions, figuring out compliance with laws in the new jurisdictions that we're entering, how to deal with an huge increase in deals. So it's all scale work. And my team is, we have 45 people on the legal team, and we're constantly every day thinking, like, what can we drop? What can we not do? What is the minimum viable that we can do? Because it's incredibly complicated being a platform that operates in so many jurisdictions. So that is probably what I spend most of my time thinking about and trying to troubleshoot day in, day out. I think in terms of substance, the topic that is, I think, most critical for platforms right now is age assurance. And I'm not sure how familiar folks here are with age assurance. And so when I say age assurance, this is the social media ban. So Australia, for example, doing social media bans for under 16s, or it's verifying age for access to mature, sexually explicit content. And so this is really, really tough. And it's AI, privacy, child safety, all rolled into one, and it's really complicated for platforms such as ours to figure out how to handle. So there's new laws coming into force in almost every jurisdiction. I think one of them was top of mind for us was in the UK. There was the Online Safety Act, and so we rolled out. We, along with every other platform that operates there, had to roll out age verification for access to mature content. So whether on Reddit, that is not only access to sexually explicit, what we call NSFW content, but also mature themed content. So for example, addiction or other things. And this was in the UK law was very broadly worded, so the scope was huge. And so we and other platforms, had to we have to ID people, right? Like you either use different methods of doing it. There's actually not great methods right now and so the tech space in this area is very immature. So either there's some are doing facial estimation, so sort of selfie estimation of age, and then the other one, the one that we use as well through a third party, is just you have to upload your ID, right? So we're getting to this part where not only in the UK, but Australia is next, because that's that's in December, and then Brazil, and EU under the DSA, France. You're going to have to show ID to go online, right, and to access mature themed content. And so it's not just accessing porn, right? It's also, so for example, the where it really hit us was accessing mature themed, for example, addiction or other help subreddits and that we have, or communities that we have. And so that's a really difficult situation. And I think for platforms like ours, we're stuck between, we want to protect users' privacy. We don't want your ID. We absolutely don't want to be collecting more data about users, but that's what we're being forced to do, right? And the best solution is at the device level. That is not, that's obviously not the way Apple and Google see it, because they don't want the liability. So they're pushing back on policymakers on that. But that is really, at the end of the day, probably the only good solution there, unless, you want to be uploading your ID to every platform. But that is definitely where I'm spending most of my time from a substance perspective, in that figuring out our compliance, for Australia, for every other country as well in this space.
Thank you. So some amazing themes came out of that. I mean, one of them is this idea of having to consider a lot of these issues globally, apply locally, data, the literacy, cleanliness, use, holding, interconnected industries. There's a whole lot going on. And so for the final question that we're going to put to the panel before we open it up to questions of the audience, it's going to be about AI, but it's not going to be about AI that they use as lawyers. Although I do believe that's an important topic. And by the way, if any of you are members of the Canadian Bar Association, there's a free AI Academy that has great online learning tools. They're fantastic. I know the guy who put it together. Through my consultancy, PGYA Consulting, which stands for Please Govern Yourself Accordingly. So my view of AI, and this is how I'm framing it for the panel, just jump in, whoever wants to jump in, is, again, this is a global thing. Changes are happening at national levels, at industry levels, at society levels. So lawyers have an influence in the broader policies, but they're largely reactive to it. But you also have a front row seat through whether it's life sciences, fintech, SaaS operations and other technology operations. You have a front row seat to what's actually happening, what's actually being implemented on the ground. My front row seat, I'm using it to help lawyers not fall behind. What are you seeing from your front row seat at like the societal and impacts? Melina, you've got a...
Yeah, so in the US right now, AI, if you're not in one of the LLMs, is all about disintermediation and data. And LLMs are mostly getting their data from third parties, and a lot of that is through scraping. We as a publisher site, along with others, are in litigation where we just sued Anthropic, so I can't talk about that one. But a lot of the law right now is very unsettled on that. It's like all a lot of the pubs have sued all of the top LLM, whether it's OpenAI or Google or Anthropic, for the use of their data. So that's a big topic for us. The other one is also is disintermediation, and that is really that the AI summaries that you get on ChatGPT or Gemini or Anthropic really kind of leaves out the link back to the site, right? And so there's a lot of concern by publishers about what do they do? What do they do in this new world, right? It's existential for them. So that is also a big topic. It's a topic for Reddit. It's a topic for publishers in the U.S. And so we're definitely spending a lot of our time thinking about that right now. I don't know. There's not really great answers. One of the ways of handling both the data and the disintermediation part is through deals. And that's like some of the work that we've done is we have deals with Google and OpenAI, but it's that or lawsuits or antitrust investigations. And that's another angle too. Anyone else?
So we as a company are leaning into AI in a huge way. I would say that, and most of that is focused on agentic commerce. So you will be able to or use an agent to go out and, let's say, book a trip for you, right? And pay for that trip using a payment mechanism that you choose, and of course subject to various approvals that would be built into the process. And we've done a couple of deals, one with Anthropic, one with Google, and I expect that to continue. I'm going to break the rule a little bit, though, Colin. I'm going to talk about how it's impacting me and my team, which is a bit different than what we heard from the private practice panel. We are, like I said, we're leaning into AI in a big way, and what that means for us as employees is that we are expected to use AI tools. And right now, a lot of it is really about experimentation, right? It's what can we do with this? But it brings up all sorts of issues that, in fact, what I would say is that it brings up enough issues that I don't know that it makes us more efficient at our jobs. I don't know that it reduces the workload. It just moves it into different areas. And I'll give you an example of this. And there was an article in the Harvard Business Review not that long ago, and the phrase that they used, and I thought it was great, was work slop. And so you have people who maybe would not have otherwise taken certain positions on things, but they rely on AI to create or structure arguments or communications in a way that makes them sound right, reasonable. And then my job as a lawyer is to ensure that if we're going to rely on that, if we're going to use it, that it's correct, right? And that means going back to basics, using Canly and other sources. And so it's a funny time right now where we are using AI in some really creative and interesting ways, and it's exciting. But at the same time, we have to be very thoughtful about how we're using it and what that looks like.
That's great. We'll ask one more panelist to jump in on this, then we'll put it out for questions so we don't run out of time for that.
Our team is using AI because it kind of feels like we don't want to fall behind. I think with a lot of people, same thing. Don't want to fall behind. We want to be aware of it. Not quite sure yet how it's going to help us. It's kind of just an advanced search engine, basically, the way that we're using it right now. Not writing content or anything like that. But throughout the company, I'm sort of hearing rumblings of different teams using it in different ways. So marketing used AI-generated voice on a video. And nobody had mentioned it to us because the content was all approved and the video was approved, and then they just used an AI-generated voice, which, doesn't create a lot of liability, but it did pronounce tech savvy a little bit funny. So, so things like that start to happen. I think AI is coming for it's coming for call centers, and a lot of our company is call centers. Most of our employees are call centers, and we're not changing anything right now. But you think of the next 25 years of AI, it is hard to imagine that we wouldn't do something. The place where I anticipate this having the first impact, where I'm going to have to actually deal with AI as a public thing, is our sort of AI-generated transcripts of customer phone calls, and then customers asking us for recordings. Customers ask for recordings all the time. We don't give them recordings. We give transcripts. And that's because we don't want our agents' voices on calls that customers then post on YouTube or Reddit. But those transcripts could easily end up out there. And if they're just AI generated, that could be a problem. If they include call notes that maybe are AI generated commentary about a call, that could be problematic. So it's kind of areas where we might start to use it and think of it as just an internal tool, but it might end up being customer facing and then create real problems down the road. So we are working on an AI policy internally, which I feels like something that's going to be required at some point. But we're developing an AI policy that for now is sort of transparency and appropriate approval mechanisms and things, as opposed to, no, you can't use it for these things because it's a small company and you want to both, that's one of the tensions of being in-house counsel, is both supporting teams who want to do things, sort of saying, yes, you can do this as long as you also do these things to protect us.
Okay, now we'll invite folks to come up to ask questions.
This question is for Jason. You mentioned that as a global company, you deal with different regulators. Out of the different countries, which one would you say is the best? And which one can we use as a guide for Canada to improve our systems? And
Can I say not Australia, please?
And then my next question, I know you're making really good bucks where you are. Have you ever thought of coming and working for a regulator to improve
Well, I started my career.
internally?
I started my career at a regulator.
I
so
know, to come back then.
In fact, I've worked for I also worked for the Information Privacy Commission for Ontario for a summer. So I feel like I've
You've done your duty.
well, and I sat on the Retail Payments Advisory Committee for the Bank of Canada with the new Retail Payments Activities Act, and was involved in that discussion from. It was actually kind of interesting. I've never done this before. From the point of identifying what the inherent risks were that the legislation was trying to address, and moving that to principles, and then from there to draft legislation and draft regulations. And I can't tell you how many consultations that I was involved in on that, and like I said, also with the RPAC. So. Yeah, I feel like we are engaged in that process, or I'm engaged in that process in a meaningful way. To your first point, who's the best regulator? I guess I would ask you on what metric? What are you measuring that?
For the position that your company has to go to different regulators, like your main mission of PayPal, if you had to go to a regulator and it's the same concept that you have to go speak around the globe, which one do you think has the best conceptualization of your company and can get to the point faster, like which country, and where does Canada fit on that?
So I'm not going to name a regulator around the world, although I will call out Australia as particularly aggressive. I think the best regulators are regulators that act in a consistent manner, that are transparent. So you can go to their websites, for example, and understand how they're going to interpret a particular provision or regulation. And those who are willing to admit what they don't know and seek guidance from those who might know more, wherever that might be. It might be industry, it might be academia, it could be public interest groups, it could be all of those things. I think the regulators that are the worst, and I would have to say that well, the regulators that are the worst are the ones that don't do those things, right? And then they, as other commentators have said, then they, when we're talking about policymakers that draft laws that don't work, or on the regulatory side, they enforce laws that don't work or in a way that isn't helpful. And when I say helpful, I'm not thinking about it in terms of the industry perspective necessarily. I'm thinking about it in terms of what are we trying to achieve at a societal level, and do these things, do these instruments achieve that goal?
Cheers.
I've been given the wrap-up sign. So if folks have additional questions, I'm sure you can find our panelists at the cocktail afterwards. But I want to thank you all for your time and talents and sharing your insights. And I'm going to throw it back to Florian.